The certificate to be, my lord. I don't. I don't. The determination. My lord, may I leave to file appeal without certificate copy, my lord? My lord, the license of amber dealer of the appellant, my lord, was by the single bench, my lord, and the respondent tried to act speedily, my lord. So, my lord, this file is necessary for the appeal. Yes, yes, my lord. Server copy I annex, my lord, and I already applied for certificate copy, my lord.
Give an undertaking that you will file the.
Yes. Huh? Yes, Guru Bhai. Yes.
Yes, take it.
But may I? But may I have a lordship leave to mention item number 5? Malat Mr. Sarwar Jahan is appearing for the petitioner. Malat one of his relative died. That's why he has not come today. Malat only praying only not today. Malat.
All right. You inform the other side.
My
Your lordship, he is making it not today, but Monday and Tuesday, I have some personal difficulty. If lordship takes.
let it be on Wednesday or any day, my lord.
As jointly prayed list on, give the date of Monday. Wednesday.
Deeply obliged.
With leave of Honorable Justice Prashad, my lord, I want to mention a matter before Honorable Justice Mr. Bhattacharya. My lord, I had mentioned this matter earlier, my lord. This matter is there in my lord's list when my lord is sitting singly, my lord. It's a second appeal. My lord, I had mentioned it before Honorable Justice Bibhash Ranjan Dey. My lord, I am humbly seeking for, and my lord, Honorable Justice Bibhash Ranjan.
I had set on Monday during the second half, entire second half.
Not instructed, my lord. I am humbly seeking for release of this matter, my lord. This matter has been allowed.
I will sit singly. Soon I will sit singly, then mention it.
Much obliged.
Lordship, may I have mentioned one matter? Lordship, Central Administrative Tribunal, Lordship, against the Central Administrative Tribunal order. Lordship, this is the Lordship's motion stage, 2013 case. The case was, Lordship, heard before the Honorable Justice Tapubroto.
Give the number. Give.
Lordship, now file is your Lordship's court, but not listed, Lordship.
Will come. If it was listed there, it will be listed.
Lordship, the file is lying before your Lordship. Kindly.
Yes.
The
Next.
pending since long, Lordship.
All the list.
I'm getting Lordship.
Item number 1.
No, no, I'm Charlie. Okay. None appears on behalf of the petitioner.
Item number 2.
I appear for the respondent union.
Yes. Yes.
My lord, I am the
Yesterday you were raising some preliminary objection in
Maintainability, because the same question is being reopened. This is the fifth round of litigation.
Yes.
My lord, in the year 1998, in the Department of Post for the post extra departmental stamp vendor post, I was selected with all other candidates after an interview and got the selected letter for and with the offer of appointment. But the appointment authority sent to me an illegal going against the rules, departmental rules and Article 16(2) of the our Circuit Indian Constitution, asked me to take up a residence under the delivery jurisdiction of the post office for which I was selected, which was illegally because Supreme Court, there are Supreme Court orders, Honorable Supreme Court orders, Article 16(2), and also the Department of Post rules and the RTI replies. I got many RTI replies and appointment letters. I got many appointment letters for the same post all over India. And then I made a representation to the appointment authority, but the appointment authority did not reply to my representation. I filed cases in the CAT, in the Central Administrative Tribunal, and the Honorable this High Court.
When did you file the first OA?
First OA, 1 minute. 1998, 99.
Give the number, OA number. No, let him give his.
OA number, the TA, that was I filed first this Honorable High Court. Then the Honorable High Court transferred to the CAT, and that was TA number 14 of 1999 in this Honorable High Court.
TA number.
TA 14, 1999. An order was passed 16 for transferred to the Central Administrative Tribunal, and Honorable Tribunal ordered date 16/4/2007. Sir, page number 137. 137.
137.
137. That order was quashed by the Honorable High Court. Then
So this was quashed by the High Court.
yes, sir.
You say that this was quashed by the High Court.
High
This-
Court, and see the sir page number 144. That was quashed. Page 144, my lord. After that, the Department of Post did not obey that order. Did not obey that order, because this order said that my case should be considered under the residence rule 4.3, chapter 4, and method of recruitment, postal EDA, conduct and service rule 1964.
Yes. Then what did they do?
Yes, sir.
After that, what did they do, the respondent?
They did not comply with the High Court order, and they applied another rule that was formed in 2001.
Then where is that
Eh,
order?
Of 2000, sir, please,
Where is the order of 2000, that order by the authorities?
at SSPO. Sir, that order was mentioned by the last order that was passed by the Central Administrative Tribunal, page number, sir, quotation was there, total orders, quotation. And another page here, I am as a finding, sir. Sir, page number 148. After the High Court orders, High Court orders, they see the page number 148. Central Administrative Tribunal quoted the appointment authorities who disobeyed the High Court order. That was mentioned here, sir. There's no 148. And this is the sorry, this is the order. Yes, sir. This is the order, appointment. Totally did not obey that High Court's order. And then I filed again in the CAT, and the CAT quoted that order with that order I told you, sir. Page number 146, C 146. Next order, 146, after the High Court order. Wa- 19 June 2012. After that, I went to the Honorable High Court, and Honorable High Court they totally in 19 June 2012 orders, way number 341 2009. In this reply, the respondent made different false statement in this reply, and so the High Court, then the High Court also did the same thing, because High Court was confused, misled, and the CAT was also, honorable judges were misled, and so their observation is right, but the order was wrong, because see, sir, 146 page number 146, 19 June 2012, third line, what the High Court, honorable CAT mentioned. Yes, sir, in case of appointment, third line, see, sir, in case of appointment, I may take the residence. In case of appointment, after appointment, not before the appointment. Same thing, the High Court, same thing. Sir, 150 page numbers, next order, High Court. 150. Same thing mentioned. In case he was appointed, one of the condition was. Sir, first para, last line, order. 150, sir. High Court order, 150. First para, last line. In case he was appointed. That was the right observation. But the respondents, day in and day out, for 25 years, they made different false statement, perjury, misleading, suppressing materials. There are many documents here with me. They won the case by misleading, by suppressing many documents, earlier judgments, CAT's order, different CAT's order, different circles in India. Many were appointed, like me. After the High Court order, I started to take RTI replies and made RTI applications. Sir, 158 page number. Then I made RTI application. RTI replies was in favor of me from the head of ADG Delhi, in favor of me. And then I made representation to the West Bengal Postal Circle and SSPO, North Presidency, Barakpur. But they did not hear me. For West Bengal Postal Circle here, representation with the RTI replies. For to give me the appointment, because I am right, I am not wrong. Date of representation. Date of representation, sir, 21 March 2017. 21 March 2017. Sir, this page, there are, sir, 25 years long. There are many papers. This page was not here, but I mentioned next time another representation. On another representation, I made that mention that date, etc. on another representation. No. They has, yes, sir. No. I made again. I filed a case with that RTI application to the Central Administrative Tribunal, and Central Administrative Tribunal ordered, sir, page number 167, ordered 167. This is the last. This is the CAT's order. 167 with that RTI application I made. They did not mention the representation in this order, and they did not mention RTI replies. See the 168 order, sir. There is no mention of my RTI replies. There is no mention RTI replies in the order. That was 8 November 2019 order. The Honorable Court endorsed the earlier all orders. They did not make any another statement, extra statement.
Then you again moved the High Court.
Then, sir, I did not move the High Court. Then I started to collect the many documents from all over India, from all of the postal service, the similarly situated post for employees, and I got different appointment letters. Page number one, starting from 174.
Yes, then what happened?
And the different appointment letters, and then I made representation with that appointment letters again.
Again,
West Bengal Postal Service, but they didn't. They hold me when waiting. Yes, I will give you reply. I will give you reply. See the representation
representation like at page 200.
to 2000, starting from 2000.
At page 200, there is one representation.
Page 200 representation, 12 April 2012.
2022.
22.
All these representations.
Another many after that 86 2024 3.
Then again you moved the cat.
Then I again moved the cat with this all these things.
OA 2191.
Yes, sir.
What is the OA after this?
868 868
Where is that? At which page?
OA sir, 83 P283. P283, my way.
83.
P283, page number.
Page 283.
Only 83.
No. What the OA is? OA 868 or 863?
868. 2023.
Then 08-868 was, what order was passed in 08?
886, so what was not for non-maintainability, the order was passed.
Where is that?
Order is last, sir, 189 page number. Um,
189.
189.
No, 189 is not the order.
Sir, 274, sir.
Two-
After 273, the order is annexed. After page number 273, the order is annexed. Last, the order is annexed.
So this is the order which you have challenged in this.
Yes. And this way was annexed with many judgments of CAT.
And
Yes.
then against this, the present rate has been filed.
Yes, sir.
After this order, the present rate petition has been filed.
Yes, yes, yes.
Your issue is already decided in WPCT 320 of 2012. That is the final decision that you cannot get the employment. After that, making representation will not give you a fresh cause of action. You cannot move the court and again after filing a RTI and after filing.
But I said I am the victim of the fraud. Fraudulent, they won the cases, and there are Supreme Court order that anytime I can challenge the fraud, and the fraud, if they win the case by fraud, the can be challenged anytime, any court, in any judicial proceeding, CAT, tribunal. There is I annex that order,
Yes.
Supreme Court orders. Anytime I go to the court, if the case is won by fraudulent way, and suppressing materials. There are many judgments with me. Because there is no residence for any employment. There is no need. Article 62 also said that in our circuit constitution. Department of Postal rules say the same thing. RTI application say the same thing.
Which judgment you are relying on?
Judgment, sir, annexed to it, page number C, sir, page number. Page number, these whatever high courts order also annexed. Sir, starting from page number 58 about the residence rules, page number 58. The honorable judges said the Kolascha Sharma versus Union of India in the Supreme Court orders. Supreme Court orders are mentioned here. Page number 58. The honorable judge mentioned the Supreme Court order 60, page number 65. Page number 65, para number 25. Supreme Court's judgments mentioned. There are many, sir. There are many. Then page number 67. 67. 67, another case. 67, department's own admission. There is no need to write residence. Page number, para number 3. Para number 3. Department's own admission in the CAT. There is no need for residence. And then sir, page number, another case, 16, page number 69. That is the High Court or Division Bench's orders. This court. This court also not required. And you said, sir, I also mentioned, sir, there is no, if I defeat the case and response won the case by fraud, by suppressing material, suppressing judgment, then I can file anytime, any case. There is the orders before me. There. দিচ্ছি আপনাকে দেখে দিচ্ছি আছে আমার কাছে Yes, this page number 22, many judgments there. Para number 22. Para number 22. Yes. Yes. কত নম্বর পেয়েছি para number 22. Asking residence rule, another High Court order residence rule, residence. Thank you. Grateful, my lord.
Anything else?
It is, my prayer is, sir, I mentioned in the petition all the prayers and supporting with the different court's judgment. I made that prayer, so
Please,
please,
you have shown it all. We have seen.
please consider.
Yes. A question regarding his statement was subject matter of the first original application. Against that one WPCT 50 of 2008 was filed to obtain the direction for reconsideration. That order was against challenge in the second original application, and thereafter the matter came up before this honorable court. WPCT number 320 was dismissed. That was not decided in favor of the petitioner.
WPCT 50 of 2008.
That was the first.
That was filed by him against the first order of the
The
tribunal.
first. And there the direction was given that the respondent should reconsider his case.
Yeah.
Page 144.
So 144, when he got the order from the writ court in WPCT 50, he must have filed a application or representation.
Yes, he filed an application and the order of rejection, again, order of rejection was passed. That is quoted in the next.
No. Where is the application that he filed after WPCT 50 of 2008? He must have filed a representation. It is not on the.
That's not here, my lord, I didn't find. But on the basis of that, the respondent passed an order. That was challenging in way number 341, whereas page 148, that order was quoted.
That we have seen, that he has already shown,
That is the order of rejection.
that he has shown us.
That is the order of rejection. Against that, the original application 341 of 2009 was filed.
So that we have seen.
And the on that, the second WPCT 320 of 2012 came up. That was also decided against the.
You have any vacancies there?
My instruction says
Is there any age bar?
regarding the vacancy, I'll have to take instruction.
But even if there is a vacancy today, that will not be of any, because he wants appointment with retrospective effect with all the back wages. Therefore, there's no point. Very good. All right. Heard the parties. CAB. Just take down his submissions. It is submitted by the learned counsel.
for a judgment. So just what judgment shall give a date, I think it is better.
আমার পেপার গুলো কি থাকবে
হ্যাঁ,
বাড়িতে আছে
It will come for judgment on 6th January.
my lord, this is the extra departmental post. I want to the departmental post.
It will come for judgment on 6th January.
Grateful, my lord.
Heard the parties list for judgment on 6th January.
Item number 3, my lord, I beg to appear for the petitioner, my lord. My lord, the petition is the land loser, my lord. If my lord recalls, my lord, went through the impugned order in challenge, my lord. My lord,
Yes. Yes.
my lord, the petitioner before your lordship is the land loser. If my lord recalls, my lord, on the last occasion, my lord went through the impugned order in challenge, my lord. Whereupon the contempt proceeding has been dropped, despite the fact that the proceeding, the order has not been complied with, my lord.
This is arising out of contempt.
Yes, my lord. This is arising out of contempt, my lord.
Yes. So therefore, we have requested another counsel yesterday also.
My lord.
That when a court refuses to exercise jurisdiction of contempt,
My lord.
then can the order be assailed in a higher forum?
Yes, my lord. There.
When the court refuses,
Yes, my lord,
the only jurisdiction a court exercising contempt power has is to punish.
Yes, my lord.
When that jurisdiction is not exercised,
Yes,
then where is the question of any case being filed against the order?
My lord, there is a judgment of the Supreme Court.
First,
My lord, but then my lord keeps it on Monday, my lord. I will show the judgment, my lord. Because this point, my lord, regarding this point, my lord, this point was raised, but in a different case, my lord, that whether when a contempt proceeding is dropped, one is dismissed or disposed, that can it be appealed, my lord. My lord, there is a larger bench charge.
appeal before which forum?
Well, because, my lord, and challenging the order of the tribunal, I have to come over here, my lord. I do not have any other.
So which judge, you have the citation?
I cannot recall, my lord.
Yesterday also we asked somebody, they told us that there is a decision of the coordinate bench.
And
of the
and my
Lordship
lord,
Justice Tandon sitting with someone.
yes, my lord, yes.
Where is that? Just show us. We are looking for the judgment every day.
My lord, my lord, then on this issue, my lord, the several my lord, there were 3 coordinate benches, my lord, regarding this issue, that contempt proceeding, my lord. My lord, Justice Tandon, while Justice Tandon was presiding over, and Justice Topobroto Chakraborty and Justice Venumani, my lord. When they were, my lord, there are judgments regarding this issue, my lord.
There are so many, but nobody is showing even one judge.
My lord, yeah, my lord, this is on a same ground, my lord, but not
We are
on the
not interested in what has been done by the court. We are interested in seeing whether,
the contempt can be,
yes,
my lord, then keeps in on Monday, my lord. I'll show my lord.
once that issue is addressed,
ma'am.
then of course everything can
Yes,
be.
my lord, my lord.
Tomorrow, not today.
But not today, my lord, I will show it on Monday.
Yes, not.
Yes. আচ্ছা আচ্ছা বলছি এটা হরিশ্চন্দ্র জিজ্ঞাসা করেছিল হ্যাঁ স্যার আছে ওটা হরিশ্চন্দ্র করে দেখিয়েছিলাম সাইটেশনটার নাম্বারটা মনে পড়ছে না Yes, Lord.
Item number 4.
Yesterday I started my argument on the statement that there was an admission on the part of the respondents at that time. Your Lordship had
You located.
well, it's their same place, my lord, but there eventually our arguments were on the basis of res judicata. I will come to res judicata, my lord, but on facts, my lord, whether this was court was recording my submissions or the I will kindly Lordship come to page 74 where the petitioner, your Lordship had noted that the submissions of the petitioner start. Well, I am not taking your Lordship to the earlier observations. The court was in contempt jurisdiction and it was only recording facts, my lord. While recording facts, my lord, you'll kindly take some pen, your Lordship.
No,
We'll
no, we
kindly
want
see
to
page
see
34, page
Yes.
34, my lord.
page
Even
34,
before, my lord,
34.
page 34, internal page 34.
Yes.
34. My lord, I will previously also same, but facts are being recorded one after another. So, my lord, this second paragraph, a chart was annexed with the affidavit purporting to show the calculation by which the pay was fixed at one.
Affidavit filed by whom?
A chart, my lord,
With the affidavit filed by which person? The petitioner.
by the contemners, my lord. But there are so many facts that is like. So, my lord, it is a recording is going on, a comparative chart. My lord, kindly come to next page. On 21/9, the court directed. These are all court is directing, my lord. Now, my lord, come on page 36, second paragraph, final chart, fourth chart on 11/6/93. And my lord, the court is recording. The respondent did not produce the records on the day specified. A warrant of arrest was, etc., etc. Service records are produced. The records of C. Konokanti has been produced. Then we're page 37 also. Serially, my lord, facts are on this background, a second paragraph. On this background, the fact that the question of alleged contumacious conduct of respondent is to be considered.
Yes.
In several affidavit in opposition filed by the respondent in answer to Rule 9(I), the defense taken is that there had in fact been no contempt committed by the respondents. No apology has been tendered by any of the respondent in any of their affidavits. Before considering the defense of the respondent, the scope and effect of order of the court which violated has been alleged and the obligation cast thereby on respondent need to be delineated. It has already been seen that by the order dated 20 September 1989, appellate court had confirmed the order and directed the court of the first instance without any modification. The direction of court necessitated the determination of the seniority of the petition on the basis of continuous length of service from 27th May 1969, conferment upon petition or consequential bidding. These directions must be read in context of the fact that they were intended to by court to grant the petitioner relief. Thus, in directing computation of seniority continuously from 27th May did not mean that if the petitioner was in service before the date, service was to be ignored. The respondent, however, in justifying the higher pay of Rishikesh Roy, has treated the petitioner as a new entrant as on 27/5/1969. This is contrary to petitioner's service record, which shows the petitioner has entered into service in 1965. Nevertheless, no grievance appears to have been made by the petitioner in this regard. Now, the determination of seniority not only meant by giving promotion, but also the fixation of the petitioner's seniority. Although the entry in petitioner, although the entry in petitioner's service book is dated 6th January 1993, according to the respondent, respective promotion by UDA was given to the petitioner by home, etc. on 24th July. The petitioner has submitted that he should have been given promotion from an earlier date because Rishikesh Roy has admittedly joined the department as LDA several months after the petitioner was promoted on the same date as UDA, which is 26/7/80. The submission, this is the recording. The submission is not acceptable. So court is now giving its own opinion. The court is this submission not acceptable in absence of particulars of any employee junior to the petitioner being promoted earlier, rejecting the submission. The choice of the same date of promotion as UDA for Rishikesh Roy and the petitioner cannot without more be faulted. Well, even in the next paragraph, this is not the submission. Well, the court is observing. No doubt there was about 1 year delay from the date of appeal courts of in affecting the promotion, but the delay in this regard is not so unreasonable as to be contumacious. This is holding that it is not contumacious. It is to be noted the order of promotion was issued before the contempt rule was issued. The question of delay is considered in great detail in connection with the discharge of other obligation, the appeals court order by the respondent. As far as fixation of seniority is concerned, but this is also the court's observation. There can be no doubt the gradation list corrected up to 31/3/89 hand circulated on 31/90 was in contravention of the order of the appeal court. Admittedly, petitioner's position in gradation list was fixed as if the petitioner had joined on 4/6/97, whereas the direction of the court was that the petitioner should be treated as in service from 27/5/1969. The correction was made after contempt rule was issued. It must therefore be held that the respondent had violated the first direction delineated above to the extent. Second direction, now court in this paragraph, relevant paragraph, court is saying whether contempt has been committed on the second count also. The second direction of the appellate court required the respondent to confer consequential benefit of the petitioner. It needs to be emphasized that both the court of the first instance and the appellate court not be understood to have empowered the respondent to reduce the benefit already being enjoyed by the petitioner. As at one stage of the proceedings, so this is where I was saying, so the court is recording this fact. At one stage of the proceeding, the respondent had admittedly refixed the petitioner's basic pay in such a manner that he was getting less than the basic pay he was drawing prior to the order of the appellate court. Even on the basis of the final calculations which were submitted on the last date of hearing by respondent authorities, we find that the respondents have not fixed the petitioner's basic pay correctly and have thereby failed to confer the consequential benefit of the petitioner till today. According to the final calculation made on 1/5/99, his basic pay as on 1/5/91 was rupees 2070. This may be compared with the basic pay of Rishikesh, who has once since retired. Unfortunately, the respondent comparative chart did not show the last pay of Rishikesh Roy. However, in affidavit of the petitioner affirmed on 25/11/90, he had said that Rishikesh Roy had drawn a basic pay of 2135 at the time of his retirement. This fact has not been controverted by the respondent, but have been sought to be justified as noted above. So this paragraph is the court's observation of the
This
facts.
is not an admission with that what you were
No,
saying. That this
no,
is
no,
an
no,
admission.
kindly read that. They have submitted a chart in the court. They have submitted, respondents have submitted.
Yes.
And they have, my contention was that I will be getting on the basis, on the same scale as Rishikesh Roy. That has ultimately lost its force due to subsequent proceedings. I am saying, at least I have failed on that count. Now you had during the proceedings yourself stated, given a chart and fixed my pay at 2070 as on 1591. Give effect to that, nothing more.
But can anything recorded in this order be taken now when the judgment is
My
already
lord,
set
my lord,
aside?
on that ground, on that ground, my lord. My lord, question of res judicata and constructive res judicata will come up.
That's not the issue. The issue is these were submissions recorded in a judgment
My lord.
which now is set aside by the court, higher court.
No, factually, it has been not on the ground of contempt. It has been set aside. That
So therefore, the facts will remain in the judgment.
the facts are not
Such a dissection.
No,
can
no,
be
no, no.
done.
My lord, if we are generalizing, then
Not generalizing, a judgment is set aside, a judgment is set aside. There's no question of general or specific.
my lord, an
Unless the
observation.
court says to this extent it is set aside, it is set aside.
No, observation of facts remain, my lord. Finding of facts remain.
So therefore, we had asked you this aspect also. Show us the law.
But that, my lord, in this case, I had, my lord, that judgment I don't have, my lord, in my.
Where the
There is
court
judgment
wants-
of 1995.
Show us, show
This
us,
was
show
this
us
was to be treated as evidence. That judgment I don't have today, my lord.
a set aside judgment.
No, no.
The-
It was set. It was on the evidence, my lord. Whether the fact which has been recorded in the court judgment will be treated as evidence under the Evidence Act or not. That was the question. So my submission will be.
That judgment is whether those facts can now be reopened or considered in favor of either party when that
No.
judgment has already been set aside.
Well, I am proceeding on a basis that this was their own admission. This they will not deny now. I am proceeding, but unfortunately, at the very beginning.
If this admission was acceptable to them, where was the occasion to challenge this
No,
order?
no, I was claiming the second part, my lord.
But the point is, if this admission was acceptable to them,
My lord.
if they did not dispute that this was a correct state of affairs recorded by the court,
My lord.
they would not have gone in appeal and got the judgment set aside.
My lord, if your lordship goes
So
through
once they have got it set aside, are we still to rely upon whatever has been said in the set aside judgment? That we are asking. Yesterday also we asked.
if my lord, I no, my lord, I was more.
Both things we said. First we said.
I was more on the res judicata, and
We are not on that aspect. We are not.
I
saying-
understand, my lord.
What we are saying is, it is not a question of matter being concluded between the parties. It is a question of anything in a judgment which has been assailed by a party.
My lord.
At their assail, it has been set aside. So now anything.
Whether, my lord, whether that the
mere
whole
prejudice recorded in that judgment
will
can
remain,
be-
will have force or not.
can be. We
But
don't-
it
prima
should,
facie we
my lord,
don't- we
it
don't
should, my
think it should.
it should, my lord. Why?
We are at difference on that.
Yes,
That
my
is
lord.
why we are saying.
I will,
show us,
my lord, I will take time, my lord, on this ground, my
because,
lord.
we
I
don't
will take
think so.
time, my lord. There is another shortcut, my lord. I will fold it
No,
hands.
we don't want shortcuts. We want to see the judgment.
No, no,
You are a specific case.
no, no.
hinges-
It is. I will. I am not escaping that responsibility, my lord.
hinges entirely on this observation.
I will, my
Made
lord.
in a judgment set aside at the instance of the person
On the
against
specific,
whom
only
you are
on the
trying-
specific point.
against whom you are wanting to use
Well,
this.
from the very beginning, I have stated, my lord, my challenge is on a very narrow compass, my lord.
Therefore,
So,
that is-
my lord, yes, I will specific
That
on.
is why we raised these two issues yesterday.
No, I.
One is whether it is a recording of their admission. To that you have whatever you have
Right.
said, we have seen, we have
Yes.
marked it.
Yes, ma'am.
The second thing we had told you that this judgment is already. set
No, I
aside.
possibly did not understand your lordship. I thought it was on the point of res judicata.
No, no,
Whether
you
the
were-
whole
you
issue can be
repeatedly
reopened.
Saying res judicata yesterday.
My fault, my lord. I'm admitting my fault. I'm not saying. I'm not saying.
Never raised the issue of res judicata.
I understand, my lord. I
We
understand.
said a judgment which is set aside by a court at the instance of a party to the proceedings. Now you want to hold something against that party from that same judgment which has been set aside.
Yes, ma'am.
So whether we can do that.
Well, on that point, you can be granted specific because it judgment on that will be very limited, my lord, on a very specific point.
You may find, we may. we don't
Yes,
know.
I may.
But this
because-
is something in our mind,
because,
we
well,
express it, then
incident-
only you can, unless we express, you cannot.
No, my lord,
Therefore, we
my lord, what I want to say, are they, my lord, I do not know. Because the whole proceeding before the state administrative was based on I have committed fraud, I have misled the court. So, well, at this point, they never even possibly the department did not even see that whether they have followed it or not. I was the submission I made. I want to take a shortcut. If they can show that it has indeed been done on this same, then I don't have anything to stand up. We need not waste any time.
See,
This is
a
no.
final
It is. I am.
This is a final calculation filed by them in a contempt proceedings. The court has looked into it. After looking into everything, the court has passed.
I
it.
understand.
They have challenged that order. That order has been set aside at their instance.
Yes. Very good. Well, I was hoping that if because since no affidavit in opposition has been filed, so at least affidavit they should have filed and said.
Unless you make out a case that we can rely on this,
Very
where is
good.
the question
Very
to ask them to come out with anything? The land counsel for the petitioner seeks to rely upon. There.
No.
See, after page 60, you have a next page 59. And therefore, we were again and again searching where is page 60 between 59 and 61. Yes, in both the briefs. The mistake is consistent. Yes. Rely upon. Passed in civil rule number
I beg to appear for the petitioners, my lord. May I please request? Lordship, on my humble submission, the coordinate bench recorded an detailed order on 4th October. Yes, my lord. Yes. My learned friend was to take instructions on these judgments, which we handed over to my learned friend on 4th September.
Everything and only to
Yes,
be mentioned.
yes, yes.
It was listed for to be mentioned. In that circumstance, would it be appropriate to?
I leave it to Lordship. I can.
Because my lord, on last occasion, my lord, I did not appear.
No, he did not appear.
No, no. Before last occasion, I failed to appear because due to the I was admitted in hospital to some operation.
On last.
On 4/10 you were appearing.
Yes, on next date, my lord, I appeared and Honorable Court directed to take instruction from the department.
No, but you must have seen the order.
What a business.
So the court has not recorded its opinion. It has just taken note of your submissions. There is no opinion of the court. So what is your instruction?
My lord, I have been told by the department to stick whatever we have submitted in affidavit in opposition, my lord. thereafter your lordship will take, my lord, whatever they will comply.
You place your instruction by way of affidavit. If a state respondent gives such instructions having suffered a judgment regarding the same rule in a different, every different
Auditor
court,
General. I am
every
appearing
different
for
court,
Auditor General, my lord.
whatever it is, you are the contesting respondent. So you suffer a judgment in one court, in another high court, you will take another view. And you will say that let us stick to the whatever we have said.
Annexing epidemic innovation one Supreme Court judgment, my lord.
That has been considered.
Sir,
Srinivas.
what we are asking you is a very simple thing. Whatever you relied upon, the court has noted in the last order. After considering everything, it has taken note of the fact that Punjab and Haryana, the Chandigarh Administrative Tribunal has decided against you, assailed before the Himachal High Court. That a judgment on this specific rule has been affirmed because SLP has also been dismissed. Still, you say that the respondent is asking you to stick to what has been stated, ignoring all these developments. Let us see this on affidavit, then we'll deal with it.
My lord, what Supreme Court judgment is there, my lord, before
All right.
That has been considered in.
Therefore, we are only asking you to do it because then they will have to have to face the consequence, not you. You place it by way of affidavit that let the respondents place on record their stand. You do whatever you want to do. Third week of January.
Do not wait, my
We
lord.
will not grant any further adjournments in the matter. It is made clear that no further adjournment will be granted in this matter. State respondent taking such a stand is very unique and peculiar thing. Every high court you must get a judgment to comply with it. Very unique instruction. Let us see.
Item number 7.
Who is appearing? You are appearing.
Yes. My advocate could not come. He had informed me by phone that he is ill and he has requested to take adjournment up to Monday. He will definitely come on Monday. But if the court thinks that no adjournment can be given, then I am ready to face it as in person. If court allows me.
Who is for the respondent?
Respondent Railway. Railway and CBI.
We had directed to inform the additional Solicitor General
Yes, I have given
after the court's order.
Yes.
Where is
I have issued a notice to Additional Solicitor General as well as Ministry of Law as well as Railway.
after 5th November?
Uh, uh,
After 5th
uh,
November.
uh.
Where is that?
I have submitted previously, my advocate had submitted the service of affidavit.
Just let us.
Railway advocate appeared yesterday.
It's 6. You have filed 2 affidavits.
Yes, one supplementary affidavit in respect of my correspondence with the CBI department. Supplementary affidavit also submitted.
August. This one. Yes, you have already served. All right. List on as paid. List on Monday. You
SK Ganguly. SK Ganguly.
Item number 8.
So next day, Monday. Thank you.
And for the respondent, it is the union's appeal. Not against
are
an
the
order.
private respondent.
Yes, my lord, the writ petitioner before the Central Administrative Tribunal. Applicant, my lord. I'm being led by Mr. Kollol Basu. I would be.
None appears for the petitioner. List after 1 week. After 1 week, Monday next. Monday.
Item number 9.
In this matter, I am appealing for the petitioner, my lord. I am filing my reply, my lord.
You filed a reply.
Reply. My lord, kindly see, my lord, the order dated 26th April. My lord, kindly see order dated 26th April 2023, my lord, passed by coordinate bench, my lord. 26th April 2023. Now I am reading, my lord, at the very outset, we must record that we do not find any.
We'll read it. Don't worry, we'll read.
ये 26 क्या? My affidavits have already been exchanged, my lord. Affidavits.
Yes.
The fact remains that all the years, my lord, affirmative affidavit they agreed to, my lord, share, they are according to the share, my lord. Both the wives are entitled for family pension, my lord. That is, my lord, kindly see page, my lord, the earlier order, my lord, passed by the tribunal, page 20, 32, 33 onwards, my lord. 11%, my lord. No, my lord, that is not. Order, my lord, 27 onwards, my lord, 27. 11%, my lord. Paragraph 4, paragraph 5, page 28. Regarding the entitlement of the, why, my lord? 6.1 of the Rule 70 of the Railway Service Pension Rules.
Why is it taking you so long?
My lord.
My lord is, my management is placing the earlier order. Your lordship kindly pay the impugned order before your lord.
Yes, my lord. They demanded succession certificate.
Not the impugned order. This is not the impugned.
No, not the impugned order. That was considered by the coordinate bench, my lord, that in that order, that was directed.
Impugned order is 3rd February.
Yes, that is.
My lord, kindly peruse this first.
The self-same judge, my lord, demanded succession certificate. But, my lord, there was no dispute between the parties, my lord. They have agreed by filing affidavit before this court. My lord, the husband. I am referring the earlier judgment of the tribunal only for referring the rules, my lord. because I have rules is not available with me.
Yes.
My lord, regarding the rules, my lord, I'm referring the earlier judgment of the tribunal.
Yes, what is the rule?
Rule, my lord, rule 70 of the
Widows. You are referring to widows.
widows, my lord.
Widows, even if they are not nominated.
Yes, my lord.
Where is this that even if they are not nominated?
Even if they are
Not nominated, if the deceased has left behind one nomination.
this is nominated respondent number 5.
Yes. So in view of such nomination,
Yes.
can it be given to anyone else?
My lord, the respondent number 5 also agreed.
Where is that agreement?
Filing affidavit. They have filed affidavit before the competent authority.
Where is that affidavit? Show us.
My page, my lord, 30. Page 30.
Yes.
My page 30.
Page
30. 30. My lord, I am reading, my lord. I Chakina Bibi.
If they are giving an affidavit, then why can't they get a succession certificate? What is the problem? Unnecessarily, you are after so many years, you are still carrying on with this affidavit.
No,
By now, it could have been done.
Yes, my that was upon long ago, my
So
lord.
therefore, we fail to understand if it is so good a relation between the parties.
Yes, my lord.
Get the succession certificate. If you
My
take
succession.
The observation was made by the
But my lord,
Justice Chagnan sitting division bench that this court, my lord, just observe that this court cannot decide
No.
the legal errors.
No, plus he is harping on Rule 75.
yes,
He is saying that it uses the expression widows,
widows,
which means more than one wife.
more than wives.
But Rule 71, you have to read with Rule 75.
Yes,
It
my
says in absence of nomination. Here there is a nomination.
nominees also agreed, my lord. That is my
So therefore, then what is the problem? You comply with this.
because they are my lord, the respondent 4 is 5 is living at Bardwan, and the respondent number the years of
You are going through litigation after litigation and you can't file one succession certificate. When you say all the parties are having a good
my lord,
relation,
after
file
so
it.
many years they are demanding, my lord.
Can be done.
At first they could demand, my lord. They at the initial stage, my lord.
What do you mean at initial stage? When you came to the court in the first round, then
No,
the
my lord.
tribunal directed to
In
consider.
the 2024 in 2014, my lord,
Yes.
I have filed the affidavit and they agreed. And the
Affidavit does not mean anything. They cannot rely on such affidavit.
and the tribunal directed, my lord.
You want to avail the opportunity or you don't? We are asking you. Otherwise, we'll decide what you are saying.
My lord,
You decide first whether you want, if your relation is good.
my lord, that is not only my lord, that is my lord, the respondent number 5 also, my lord.
You are saying that respondent number
She is
5
appearing also. She is appearing.
correct. She may be appearing. She may be appearing.
Yes.
Go and file the certificate. What is the big deal?
My lord, that
Yes. You are for respondent number 5.
5.
The second wife.
Third.
Third wife. No, he is.
Second wife.
My name is appearing.
You are the third wife.
What has happened? Very short matter.
No, we are not required to go into all that. We don't want to. If you are agreeable, you get a succession certificate. So after since 2020, you are roaming because you did not give the succession certificate. The tribunal told you in 2020 to give a succession certificate. Till 24, you are moving in the court. Yes. Correct. That you have challenged in 20. Yes. Yes. Yes, you are entitled. No, but if the petitioner's counsel agrees, it can be done. This is not your writ petition.
Yes.
It is her writ. It is not your writ petition. It is her writ petition. If she is agreeable to this submission, then it can be disposed of. If she is not, then she will have to go for a succession certificate.
She is agreed, my lord. My lord, only family pension. Regarding family pension, my lord, division will be made.
Yes.
Otherwise, my lord, that will not be nominee. Nominee regarding family pension, my lord, nominee has no role, my lord. Family pension be divided only prior, my lord.
Cannot be divided without a succession certificate. In absence of nomination, how it can be done? No, that we have understood. We have understood what you are saying. Yes.
They are very poor person. I am doing this matter without any.
You have portion. That is the best way to do it. If you are in good terms.
My both.
Yes, I will pay. I will pay. Whatever she wants.
Whatever is her due.
Actually, petitioner is a beggar.
So he is
came to my house for
why are
begging.
you arguing when there is no dispute? Why are you arguing? When she is saying that she will give you all of the dues, she will give it to you.
Yes.
Agree with my proposal.
Yes, my lord.
Yes.
Only family pension will be divided after, my lord.
Not by the court's order. They will give you. She will give you. Court will not divide.
Then file a succession certificate. Then you are able to secure the amount.
Can you file an affidavit to this effect?
I can file, but my client is.
Just one-page affidavit saying that whatever is her due, you will give her.
Yes,
You file that, will dispose it off.
Fine.
Then you make the payment to the nominee.
So far, my instruction is concerned, the validity of the marriage is in question. That is not permissible.
The nominee's validity.
Yes, my lord, the marriage validity. My lord, widows are entitled, but that there should be, my lord, valid marriage. And the third wife also, when she did not divorce, my lord, she get married to this person. They are not entitled. Legally married wife, if more than one wife, entitled.
No, we are not on that. When we are saying when a nominee has been made by the deceased, then where is the question of legally or illegally? If she is a nominee, she is a nominee.
Nomination.
Is there any bar that only wife can be a nominee?
No, my lord.
Then why are you raising this issue unnecessarily?
Your lordship, kindly pay to my affidavit of
We have understood what you are saying. You are saying that the nominee is not legally wedded because during subsistence of an earlier marriage, that is none of your business.
I follow.
Where is the requirement of a nominee being?
When there is a nominee, irrespective of the fact,
You give to the nominee.
Or no widow, she is entitled.
You give to
that one. I notify.
Therefore, if
I also take instruction to my.
then unnecessary arguments. Yes, take down. All right, the writ petitioner claims to be the second wife of the
Item number 10.
yes, just at the top.
Your Lordship, if I may make one humble submission, in this matter, Your Lordship, Mr. Tonoy Chakraborty, learned advocate, is appearing on behalf of the added respondents, Your Lordship. 6 to 21. Unfortunately, due to some personal difficulty, he couldn't come to court, and I was requested by him to pray, Your Lordship, only for 1 day's adjournment. If Your Lordship may so please, sir. May I grant so. Only 1 day's adjournment.
I just filed the activity because I served upon them.
And all respondents are now represented.
Yes, Your Lordship. 6 to 21, I am told that Mr.
No, we are asking you all, we don't know 6, 7.
All respondents, PSC is appearing.
All are represented.
State are also appearing. All the affidavits complete.
The affidavits in reply, the affidavits in opposition and affidavits in reply.
Item number 11.
Appearing for respondent in this matter, Your Lordship.
You're for the petitioner.
No. Next.
Today is the second occasion when there is no representation.
Eleven. But I'm sorry.
We are repeatedly asking, yes. What is it?
My lord, kindly give me short password, my lord.
No, last day there was no appearance, you start, we'll hear you. Give the file.
I am appearing on behalf of the respondent in this matter. Learned ESG is appearing in this matter is not well. I am praying that the matter may be taken up on Wednesday, Your Lordship.
What is this? Every day is on the ground of ASG, you want an adjournment. What is this? In every case, on the ground of ASG, adjournment is being sought. Why? Consistently. Today also in another case, he was not there. Yesterday also. Every day adjournment on behalf of ASG. Why? Sorry, you please, you get the brief. You assist us. This is not the way. Yes.
Kindly short password, my lord.
Why? Last day also there was none to represent the petitioner. You are not interested. Why do you keep the matter pending? Let it go. The casual adjournments are very casual adjournment. Just for the sake of adjournment.
Let counsel Mr. Amrita Mandal, he is engaged another court, my lord.
He will come, you start. Yes, what is it? What the tribunal has done, let us see.
Impugn order, date impugn order, impugn order. ওটা পেছনে থাকে পেজ নাম্বার খুঁজছি ইমপ্লিমেন্ট অর্ডারটা অর্ডার আসছে 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 মামলা করছে এখানে বাইরে গেছে আসছে ইমপ্লিমেন্ট অর্ডার বলো 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 অর্ডার ডেটেড 22/3/2023 কি মিটিং করেছে একটু অর্ডারটা দাদা করাতে বলছি একটা করো না তারপর কিন্তু অর্ডারটা শেষ করো কোথাও টাকা চলে আসবে Fast by tribal. Administrative. Start করো start করো বললো আমাকে start করতে start করো start করো
Extremely sorry, Your Lordship. Yes. I'll say that to you. Okay. But only one thing I would like to submit, subject to Your Lordship's permission.
Yes.
Yes, my lord, in the reply that they have filed, they have already made a statement that they will consider my lord, application. They would like to consider my application. If your lordship kindly comes to that.
Affidavit in opposition.
Affidavit in opposition, your lordship. I'm very sorry. Affidavit in opposition.
Which page?
Yes.
Which paragraph?
Yes, my lord, I'm stating to your lordship. Just a moment, my lord. Hmm. Yes, my lord. My lord, at page 6, your lordship sees. Page 6, the topmost paragraph, your lordship sees kindly, is now ready to reconsider the case of the petitioner. Miss Pandey is representing, my lord, the respondents. My lord, I had an unofficial talk with her. She said that they are willing to, my lord, give me the
paragraph 6.
Yes, your lordship. Page 6, your lordship. Page 6, paragraph 14, the last part. And it was repeated thereafter as well. At page 7 also. 17B also it was repeated. Miss Pandey is there, my lord, on the virtual mode.
Your Lordship, I'm not well, so I had I couldn't appear physically, Your Lordship, in this matter. In this, we had stated that we will reconsider, but as they are going on merit of the matter, so Your Lordship may decide the merit of the matter, because they are not desirous of going before us that we review the matter again.
No, he is submitting that he wants to avail this opportunity that you have.
Your Lordship,
my lord,
we are not
my lord,
standing
sir.
in the way. On the last occasion when he had submitted, that is the reason when we had filed the
My lord, I do not want to go back to them for reconsideration, because if I place the matter before your lordship, my lord, I am very hopeful that we'll get through this. My lord.
Then why are you pointing out this?
So, their point that they have taken in their opposition, that I am relying, your lordship.
Your Lordship, we had given, but if your Lordship
They
so
themselves
decides,
say
your
that they
Lordship
want to
decides
reconsider.
it.
Very well, my lord, I'll start in that.
If you are not interested, then there's no point in
Very
saying that. That doesn't better your case in any way.
Your Lordship, my only prayer was that I could assist your Lordship better if it could be fixed on any day or Tuesday or Wednesday, subject to your Lordship's convenience.
Just let us hear him. Yes.
Your
Yes.
Lordship.
Excuse me. My lord, the father of the petitioner number 2, my lord, was working as a postmaster of Bardhaman division in the Gohagram post office. The father, my lord, expired on 2nd of November 2009. Death certificate, which, my lord, I have annexed at page 65.
All right, you applied on 5/2/2010.
Yes.
You are considered, you were awarded 28 marks.
No, my lord, that is my contention, is that the merit point system would not be applicable in my case.
So don't say no, you were awarded 28 marks.
Yes.
So that is a yes, not a no. But
That
you
is a
say
yes.
You are not, you should not be subjected to this mark system.
Yes.
Because at the time of death of your father in 2009, this scheme was not applicable.
Yes. Not also when I have applied.
Correct.
Both the times.
Correct. We have
Yes.
seen that sequence
Yes.
of dates.
Yes.
That is your case.
Yes.
But it appears thereafter also you have been considered.
No, thereafter there was a call by them for reviewing.
For review.
Yes. In that review also, my lord, my case has not been considered. In spite of the fact that the candidates who were elder than me and whose age had crossed the age of 40 years had even been considered. But not my case was
They
considered.
called you for review.
Yes, my lord, I was within the, my lord, purview of the review.
No, they asked you to come for review or
Yes, they asked me to come for review.
having rejected your case.
Yes, because that was the decision taken by them, that the persons who have been rejected on the basis of the merit point system would be called for review again, as on the basis of the date of application and as on the basis of their age on the date of their making the application. But in that review also, my case was not even considered at all.
Yes.
So that is my grievance before your lordship.
So let us see, then it's only an issue of law.
Yes.
What is
Whether the merit point system
will
would
apply
be
or not?
applicable in my case or not.
Where is the judgment?
No, my lord, I have placed, my lord, here only. My lord, the merit point system had been abolished.
Sir, we are asking you, where is the judgment?
My lord,
Issue has fallen for consideration before the apex court. You will get a judgment.
Yes, absolutely, my lord, my lord. Your lordship kindly fixes any date, my lord, I'll come with the
This is
judgment.
the only issue, and you are coming without a judgment.
My lord, it fixes any date, my lord, my lord. It is there, my lord, it could not bring it today, my lord, I'm any date.
জাজমেন্ট এখানে দিয়েছিল
জাজমেন্ট দেবো না, এখানে পচা পচা জাজমেন্ট আছে। আছে আছে
বের করা আছে
হ্যাঁ, কিন্তু কপি করা যায়।
Your Lordship is not audible, Your
You
Lordship.
also come with a judgment on this point.
Your Lordship, I have found a few judgments. That's why I wanted to place this matter was placed.
So
My
we are-
learned senior, Mr. ASG Ashok Chakraborty, is leading me in this
The
matter.
only issue is which scheme is applicable, which
Yes.
under which scheme his case has to be considered.
The affidavit, the last affidavit we have also said that we are ready to reconsider.
No, he doesn't want to go because he says I must be considered as per the rule prevailing on the date of application.
Yes.
So
But
then
your officers are aware that the Supreme Court latest view is that at the time of consideration of the application, the relevant laws are prevailed.
where is that justice, Lordship Justice M.R. Shah's judgment? Where is it?
That is actually my learned junior's voice was choked and my voice is also choked. So that is why we are in a little bit difficult.
We have seen a judgment.
Kindly ask them to decide the issue.
No, you come with it. We'll decide here only. We'll see the judgment and
Better
we'll
than
decide.
kindly place it on some other day.
The issue arising for consideration is whether the petitioner's claim It cannot be. Fourth is a Saturday.
Oh, very sorry, my lord. Then the next Monday, subject to your lordship's convenience. Sir.
Next Monday.
মানে third এর পরে 6 January.
6 January.
Very well. Deeply obliged, your lordship. Deeply obliged. বসে পড়ো, বসে পড়ো। বসে পড়ো, বসে পড়ো, বসে পড়ো। বসে পড়ো। নামগুলা লিখে দাও, আমরা লিখে দাও।
Number 12.
My right petition, man. My petition, my last occasion, my lord, direction was made, my lord, for opposition, my lord, no opposition, my lord, given, my lord. Kal, my lord, stand, my lord, last annexation, my lord, the impunge order, my lord. The petitioner is only the unfortunate candidate, my lord. All over West Bengal having this 9 my lord, library assistants. My lord, all of the 8, my lord, get this case pay, my lord, due to the, my lord, enhancement is the qualification. Only, my lord, petitioners cannot getting this pay. This is, my lord, the only, my lord, that they have the delay, the reject my application on the delay.
On 17th October 2006.
2006.
17th October 2006. That is the page 51.
Yes. For the librarian scale for bachelor's degree.
No, my lord, first, my lord, petitioner got an appointment in the year 2000 to 2002. Kind, my lord, turn, my lord.
What is the claim? What is
my
your
lord, claim, my lord,
which scale?
My lord, the library after, my lord, I am the assistant library. My lord, got the appointment, the compensation appointment. And then after, my lord, in the, after taking the permission from the authority concerns, the enhancement, my qualification, the library science. And after enhancement, the qualification, I made application 2005, and my lord, authority concern reject my prayer.
So library assistant having bachelor's degree.
No, my lord, no. At that time,
My lord, his bachelor's degree, but library library degree for bachelor's degree. That is all.
That is what we are saying. Repeatedly asking you. We don't need the history.
As per ROPA 81, my lord, the library assistant will be enhanced to the scale number 10, and he is claiming the scale number 10.
Claim number 10 after attaining the bachelor's degree.
Yeah.
So when
there
did
are
you
already 9 candidates, 8 candidates so were already allowed the higher scale of pay. Only the petitioner.
So when did you acquire the bachelor's degree?
2005.
Huh?
Igloo.
When did you acquire the bachelor's degree?
2004.
2004.
Yeah.
And you made an application in 2006.
5.
2006.
No, 5.
2005.
2005.
2005.
What is the date?
My lord, 17 May 2005.
17 May 5 is your application. And what is the date on which you acquired the qualification?
2004, December 2004, my lord.
No.
21/12, 2005. How can 2004?
Yes.
Oh. Right.
Uh-huh. 21/4/2005. And you made an application on 17/5/2005.
Yes.
The last order, the last candidate who allowed the higher scale of pay with retrospective effect on 27 June 2024, my lord.
So where is the delay? They have applied in May 2000. Why? Oh, it was rejected. It was rejected in 2006.
But my lord, in the rejection letter, the two names were appeared. One is the petitioner, another name is Babli Vishwas. The Babli Vishwas was allowed the higher scale of pay.
When? She must have come to the tribunal immediately.
2019, my lord. Page number 66. Page number 66.
So therefore, what is the way number?
1
2017.
আরে এটা তো চ্যালেঞ্জই করুন কেস করলো
Court fence sitter, a salary every month cause of action arises. And salary is not a continuing cause of action.
No, fixation of pay. There was rejected in 2006. Then under section 21 of the Administrative Tribunal Act, maximum 1. That was further reconsidered, my lord. The rejection letter further reconsidered.
All right, just you wait, Miss. Yes, towards
Case 23, my lord.
case 23. When was it reconsidered? What is the date?
my lord, another application made in 52 my lord, thereafter my lord another application after giving the particulars of this can 52 page application 28th June 2011 after giving particular who have got the appoint the get this pay scale.
Where is the initial rejection of 2006?
Kindly, my lord. Only my lord the 51. The undersigned is directed to say that government of West Bengal in the technical education and training department expressed its inability to enhance the scale of pay of library assistant to that librarian in favor of Sri Raja Chakraborty, library assistant, Asansol Polytechnic, and Srimati Babli Vishwas library assistant ke Jalpaiguri ke Polytechnic Institute Jalpaiguri. This is the initial 2000, and thereafter petitioner made an application for after giving the particulars who have got the same and identical cases the gun, and this is the next page 52 for reconsideration.
Again, it was
Then
rejected.
thereafter 55 my lord. My lord,
Rejected.
no my lord, never rejected. There is the pending. My lord, the 55. Thereafter 55. Commissioner asked the director in charge produced all the relevant records. 4th April 2016.
Who is responsible? Who is the competent authority for granting it?
Okay, responsible.
Commissioner or the director?
Director.
Respondent number 5. The director has lastly passed, my lord. Another order.
Yes. Huh?
There is the order. Another person which was passed for 27.
No, after this, what happened?
But there is nothing, my lord. Thereafter tribunal application was moved.
So after this, you got this letter that it is under consideration.
Yes, under consideration. My lord, if the under consideration, means how to my lord ki limitation will lie, my lord. There are operation and the prayer of the kind my lord ki tribunal application prayer, my lord. $37.
So this was this letter of the commissioner.
Yes.
In this, both the person's case was being considered.
Yes.
And the other one has got it.
Yes, one of the got it, my lord, ki doing my lord, petitioner only the left out candidate. This is the order.
Just wait. What is that page 56?
He was granted for the promotion for UDC, but he rejected the promotion because the UDC post is the administrative post, my lord, but he is working in the library assistant post.
When did you file the OA? 2019.
2021, my lord, 21, my lord, the prayer of the OA application, my lord, 37.
And when was it when this other person has been granted after the tribunal's order?
Yes, my lord.
Both the suit were filed at the same time, my lord. Another person was allowed the retrospective retrospective.
No, both are not filed at the same time. You have filed after 3 years. 3 years. Yes, now.
My lord, in this, my lord, the one judgment, my lord, the fixation of pay scale, my lord, the no, my lord, delay, my lord, this is the my lord reported in AIR 1996 Supreme Court 6, 7, 8, 9.
Continuous cause of action.
Yes, my lord.
All right.
Here is the last order passed for the another person.
Which judgment you are relying on? Give us.
Nimar Gupta, my lord.
Nimar Gupta. AIR 1996 SC. Paragraph 5, page 669.
Yes, this is a settle of mark. Yes, you are relying upon Tribunal Administrative Tribunals Act.
One small thing.
Yes.
Last representation on 13th. In case where an appeal or representative order maintaining costume of subsequence have been made, the period of 6 months expired before without filing order made within 1 year from the date of expiry of the state period of 6 months. Before the legislation to 2021 about more than 10 years. He could have filed an application on confirmation of delay. No such application was filed before the tribunal.
No arrears.
My lord.
No arrears.
But in the last order, the person concerned was allowed the
You are relying on a judgment which says no area. You could have come with other judgment, but you have come with this judgment. Third learned counsel for the petitioner as well as the learned state counsel. The
Item number 13.
Usual running. My lord, on behalf of the petitioner, my lord, kindly, my lord, Passover or next week, my lord,
This matter.
This matter.
Next
Passover.
Next week will be mine. So mine can be because the doctor has advised not to speak much because of the pharyngitis and pharyngitis. Oh. Next week.
Then it will come post Christmas.
Next week on market. On 13th.
13th. As prayed, as jointly prayed. List on 13th. 13th December.
Get
Item number 14.
Well, item number 14, 15, and 16, the issues are same. My lord, I may say, my lord, this matter has been dealt with by your lordship, my lord, sitting with my lord Justice Harish Tandon. My lord, it's a resignation of a doctor, my lord, who got an appointment in AIMS, Kolani. Now, my lord, your lordship takes up the order by which the tribunal directed the authorities to consider my case. Although, my lord, in the original application, I have prayed for a mandatory direction, stating therein the orders of this court, which is binding on the tribunal. Now, my lord, the learned tribunal directed and delegated the powers to the authorities concerned. My lord,
What did they do thereafter?
well, after, my lord, they did nothing. My lord, we moved the writ petition before this court, as because my lord, date of joining was very soon at that point of time. Now, my lord, same with Dr. Rana. Then, my lord, on 15/1/2024, my lord, the coordinated bench grant us interim order to the extent so that I can join the post. I joined, my lord, accordingly. Now, my lord, in the midst of this, when the matters are being seen with this honorable court, my lord, on 9th of January, one purported order is set to be passed. That was also there in Dr. Shumi Rana's case. Now,
January.
9th of January.
24.
24. My lord, they have passed the purported order stating there is a dearth of doctors.
Public interest.
Public interest, dearth of doctors, we cannot let you go, and so on and so forth. Now, my lord, this issue, I may say, my lord, is already been decided by your lordship, authored by your lordship, my lord, and now nothing is more res integrata, my lord. Issues are settled, my lord. I am a doctor, my lord. In this case, your lordship will find this Gaurav Lojan Chaudhary, that very case, wherein in all three cases, my lord, I have to approach this tribunal, thereafter this honorable court for getting the NOC to participate. My lord, WPST 120.
In this case also there is issue of NOC.
No, my lord. This very petitioner was a petitioner in WPST number 127 and 137, wherein the honorable court allowed my NOC with a specific averment that I have to make an affidavit. I made the affidavit that if I get selected, I will resign. My lord, I got selected, I resigned. My lord, thereafter, my lord, nothing happened. I approached the tribunal, and thereafter from tribunal, I came before this honorable court. At that very juncture, my lord, when the matters were pending before this honorable court, they passed the purported reasoned order, my lord, I may say, my lord, stating the dearth of doctors. But, my lord, that was also taken up before the coordinate bench on 15th of January. If your lordship sees the order, although it says an order was passed, nothing more. There was no leave granted by this honorable court to pass such orders, but they have passed such orders. Now, my lord, keeping the, my lord, the balance of convenience and inconvenience in favor of the petitioner, my lord, the coordinate bench allowed us to join. My lord, these three doctors joined. The fourth doctor also, same order was passed, same interim order. My lord, IIT didn't allow him to join, so, my lord, we have to move the petition before lordship. Your lordship ultimately decided Dr. Shumi Rana. Issues are same.
That matter was considered by
your lordship, my lord. By your lordship authored the judgment.
That IIT doctor.
Your lordship has authored the judgment, my lord, and now, my lord, things, I may say, my lord, it's no more res integrata. These issues have been time and again taken out by this court. And, my lord, your lordship, while deciding the, my lord, Justice WPST 3, your lordship pointed out a question to my learned senior friend is that there must be a state policy. Time and again for the same issue, one should not be, my lord, coming before the courts, which has been long been due settled. My lord, this is your lordship's order.
Direct them to make a policy. If they don't
My lord,
want to make a policy.
My lord, this is your lordship's last order, my lord.
What affidavit, sir? Same, you want the same order to be passed in everybody's case?
Court has dealt with the matter.
Let us.
Judgment of the state of West Bengal versus Contempt.
That is regarding here.
My lord, these are
The voluntary retirement.
my case is resignation.
Regarding?
Voluntary retirement.
Where is the? Now, if the state will have to face some consequence if these matters come up every day. This can't continue like this. You have no litigation policy. In every matter, you want the same judgment to be reproduced. This is not expected from a state authority.
Kindly see your affidavits.
Is it open to a state to take such a plea in every case, having suffered a judgment?
Kindly see the
No, we are not going to look into a VRS matter. We are not going to look into a VRS matter. It's not an issue of VRS.
according to the order of the tribunal. Case of Code of Chaudhary, but a case has been considered on 18th January 2020.
No, sir, we are asking you a very simple question. You want in every case orders to be passed for them to be given.
No, that
Please say this on affidavit. We will say this on affidavit. We will deal with the situation. This can't be allowed to go on.
Kindly see our affidavit.
No, we are not going to see any VRS matter. Why should we? It's not an issue of VRS. Why should we see a
It is a
VRS?
case of resignation.
Simpliciter.
Simplicity of resignation.
Yes.
But let him give an undertaking that he will not claim any pay.
Has he said he will not give an undertaking? Has he said that he will not give an undertaking? He must have said in the petition that he is willing to give an undertaking.
Already given.
He must have said in the petition. By now, I have seen at least 6 petitions like this. Now the state should suffer some consequence. Then this can't be. This is not the way a state is supposed to take on the litigation. For every individual, you want the same order.
As an ordinary citizen, I can say that most of the people, more than 80% people of the total population of the irrelevant courts are depending upon the medical facility by the government.
Same.
You cannot say. You cannot say it now. In every case, you cannot say the same thing when it has been rejected. That is what we are saying. We are not asking you whether public is entitled to a health care and how you should manage your affairs. We are not looking into that. If that issue comes, then we may be required to consider whether you are to manage your affairs, how it is to be done. We don't want to go into that.
We don't know nothing except we are qualified.
We are asking you a simple question. Are you going to continue doing this in every case? You file an affidavit. Why the same objection is being taken after the court has already decided? How can you do this as a state? In every matter, you want the same order to be passed. It's like we are churning out a copy of the order in respect of every petitioner. Same ground and same rejection and same undertaking. There has to be some policy with regard to such litigation. It can't be. How many matters are pending? You give us a list. We'll have to pass some order in this regard. It can't be allowed to continue like this. This you can't do. You take up matters, you did. We are here to decide things. But this is not the way. The same objection in every case, the same order in every case. And here again, you are repeating the same ground which has been rejected by now at least 20 times. How can Therefore, we are addressing you. You are not only a master of your.
I'm little understanding of law. Whatever passes through your lordship's mind, I shall have to communicate to my clients. But when people are trying for the medical treatment. When I hear rejection. When an order is passed, it has to be obeyed, nothing more.
সুপ্রিম কোর্টে টেস্ট করেছে বলে সুপ্রিম কোর্ট টেস্ট করেছে আদারওয়াইজ মানে কি সুপ্রিম কোর্ট এসে তোমার জয়েন করেছে কবে
অনেক আমরা অনেক আগে
জানুয়ারিতে
না না না
না না না
এখানে সার্ভিসে অনেক 19 বছর চাকরি করেছি 19 বছর অনেক আগে
You lose the 19 years certificate.
হ্যাঁ আমরা
Lord, I am going to serve the aims. I am a medical. No, yes. Going to lose.
আমি অনেক
So no, he is saying, Lord, my. Right. Right. Right.
Yes.
Wasar also did even they like to be audited individual because they see the postal that about more than 60% cases in the High Court state is the one of the individual. No. Just like after shape because to the order after shape
Right, you're absolutely correct. Absolutely. Page 45. Page 45, 46.
45 46 আর আন্ডারটেকিং
Affidavit দেওয়া আছে স্যার আগের পিটিশনে affidavit দেওয়া ছিল
হ্যাঁ আচ্ছা
আচ্ছা স্যার পেজ 46
45
46 এ যান প্যারাগ্রাফ 4
পিটিশনের বডি তো দেয়া আছে
46 56 5টা দেখুন স্যার
53 তোমার রেজিগনেশন লেটার হবে
এখানে তো activity আছে
on the basis of this undertaking, the government will be adequate. Or the current record my successor. I was very small man. I have no political affiliations. I don't recognition from anybody except this honorable. I don't have any recognition from any other party except this honorable. And I'm grateful to this honorable. I'm very little bad. Well, may I suggest one thing? So that government advocate no. So that
আপনি বলে দিলে
সোমবার দিন
it would be better for the observation is communicated the standard advocate. He is the chief law officer. No.
Lordship,
Executives are passing an order for complying the mandate. Nothing else. And they are obligation to do so.
Lordship, before
Wednesday. But 14, 15, 16, all three are identical, my lord.
Lordship, before you,
Yes.
Lordship, before your Lordship,
My lord, I may say, my lord, this matter, one of the matters has been tested before the Honorable Supreme Court even. My lord, they ultimately withdraw the application. My lord. So these same, no. Dr. Devarati Chattopadhyay, Dr. Mata.
Lordship, before you, Lordship, rise the next matter, Lordship, item number 17. There are two more matters on the identical issue, Lordship. They've not appeared. So if they could. Yes, Lordship, but what I was praying for, Lordship, I'm appearing for the petitioners. The impugned order arises from a batch of 45 original applications. I have 9 affidavits in opposition to reply. Lordship, I was just going to seek time for that. That is why I was saying that.
Yes,
Other
but
sides are all
I'm for the respondent.
Mr.
7 respondents I am.
Lordship, I would like if one affidavit is ready. For this one, it's ready. For a fortnight, Lordship, it will be better than come back. And supplementary.